On Thursday, the 13th of November 2014, the Guardian newspaper ran an article by Roy Greenslade headed "Time for an Investigation into the Fake Sheik After Panorama Revelations." This followed the BBC finally broadcasting, after numerous delays, BBC Panorama, the Fake Sheik Exposed, in light of the July collapse of the Talisa trial in 2014, where Mahmood was exposed as a perjurer and fabricator of false evidence, and ultimately in later years would be jailed for that. And tons of other evidence will come to light, but it raised some very interesting questions that Roy Greenslade made in that article. So I'm going to read you them because they still have not been answered. The outstanding questions from the Panorama programme. Question 1. Why did the Attorney General, who at the time was Jeremy Wright, ask the BBC not to screen that edition of Panorama? It was an unprecedented intervention by Britain's senior law officer to prevent the screening of a current affairs documentary that was clearly in the public interest. Mahmood had not been charged with any offence. He may be under investigation because of the judge's comments about him when staying the trial of Contos Davlos. So what? Note what a former Attorney General, Lord Goldsmith, told the programme about Mahmood's record of convictions needing to be re-examined. Quoting Lord Goldsmith on the Panorama, he said, "The fact that somebody who has been accused by a judge of apparently not telling the truth may be instrumental in those convictions would certainly be a reason to look at those convictions again and to examine them to see whether they are safe." It beggars belief. Question 2. Why did the Metropolitan Police go on acting in concert with Mahmood on a series of occasions after evidence had emerged, as in the 2003 Beckham Kidnap case, that he had used an agent provocateur? And question 3. Why did the Crown Prosecution Service continue to prosecute people entrapped by Mahmood after so many courtroom reverses, such as the Kidnap and the Red Mercury case? All those questions still remain, but they're actually bigger questions now because of the evidence I have in my possession and mentioned at circusofthemind.net, namely that the police and Crown Prosecution Service both communicated with each other in 1994 in writing, stating that Mazher Mahmood could not and should not ever be relied upon as a witness of truth ever again. So why did they turn a blind eye for another 20 years? 94, 2004, another 20 years till the collapse of the Talisa trial. Why did they never disclose to victims like me and other Mahmood victims the information they had, that they knew Mahmood had already lied, causing trials to collapse? There are multiple occasions that there's evidence of now where Mahmood lied or fabricated evidence, cases collapsed, and those things were never disclosed to me or any other victims, despite the fact they should have been under the 1996 CEPA regulations. This is all mentioned at circusofthemind.net. Question 4 was, why have News UK's two daily papers, The Times and The Sun, not covered the story about Panorama's struggle to be aired, and of course about the substantive issues it has raised? Well, obviously that's because they knew what Mahmood was up to, I would assert. Question 5. What was Mahmood's relationship with Southern Investigations? He told the Leveson inquiry he'd never paid for the services of a private investigator. But Panorama revealed that a member of that company, a former police officer, took part in at least one of his sting operations. How come? Well, the truth is, where we are now, 10th, 11th, 12th, 13th of June 2026, I now have evidence, as do other fake Sheikh Mazher Mahmood victims, that he routinely used private investigators, unlawful information gathering, and illegal phone hacking. Indeed, I have a witness statement from the late Greg Miskew, who was kind of Mahmood's boss, stating that he acted as a go-between between Mahmood and phone hacker Glenn Mulcair. I also have a statement from Glenn Mulcair confirming that he was tasked to do phone hacking on my phone in relation to the fabricated nonsense 1998 News of the World story that was run on me, which led to my convictions in 1999, which are unsafe. Indeed, they would never have come to court if the police and Crown Prosecution Service had disclosed to me the knowledge they had that Mahmood's testimony could not be trusted, because they'd written to each other in '94 stating he could not and should not ever be relied upon as a witness of truth. If that had been disclosed to me, as it should have been under 1996 SEPA rules, then I would never have changed my plea from not guilty to guilty on the first day of trial, which I was effectively forced into doing because Mahmood's sources were protected. So it became impossible for me at that time to prove that his only apparent source for a story was me suggesting to him in writing that he should do a story on Britain's biggest media prankster. It sounds stranger than fiction, but if you go to circusofthemind.net, you can get the full details on this. And also at the link above or below this, there's a link to my interview with Sonia Poulton's Wake Up with Sonia show, where I explain this in more depth. The bottom line is, had I known then what I now know, which I should have known because the police and Crown Prosecution Service were under SEPA 1996 rules, should have disclosed these things to me because they were relevant to the credibility or lack of credibility of their chief witness, Mazher Mahmood. And now, thanks to disclosure I got in Alex Smith versus News Group newspapers, which I filed on the 30th of September 2022 in Transfor of the Mittville, the mobile telephone voicemail interception litigation. During disclosure, I got the secret videotapes, audios, and everything I've ever said, everything I've ever stated from 1998 onwards has now been proven to be completely true, as I always knew it was, but now I've got video evidence, audio evidence, documented evidence, photographs, receipts for the payment of private investigators, for payments to Glenn Mulcair, for phone hacking, and a whole bunch of other stuff that shows that Mahmood never told the police or the CPS the truth. Not only did they not disclose things to me they should have done, but also Mahmood never disclosed things to the police and CPS he should have done. Things that if he had disclosed, then my case would never have gone to court in the first place. And because of that new evidence and the fact that I got an apology in writing from News Group newspapers in early 2025, apologising for the actions of Mahmood and his associates, that combined with the non-disclosure by the police and CPS and a whole bunch of other things I can now prove, such as I assert that my drinks were drugged, and the video evidence seems to suggest that as well. Well, all these things together show that my convictions are completely unsafe. They always have been and should be overturned, as per the details at circusofthemind.net. I filed my reapplication to the Criminal Cases Review Commission on the 3rd of February 2026. And a few days ago got a letter saying that it still hasn't been given to a case review manager because they've got a backlog. Bloody hell. The fact is, I've had an apology for his actions from News Group newspapers. That proves that he did not disclose things to the police and CPS that were pivotal to proving the fact that he acted dishonestly, unlawfully and arguably illegally in many fashions. The police and CPS did not disclose what they knew about his dishonesty, and to this day they haven't. In fact, in late 2025, I gave the CPS an opportunity to disclose what they knew to me and provided them with the proof of the knowledge I now have and evidence of various cases collapsing due to Mahmood's dishonesty that's never been revealed to me or any other Mahmood victim. And they wrote back and said they would not communicate or engage with me any further and would not disclose anything to me, which frankly is a breach of SEPA 1996 rules yet again. To me, it suggests cover-up on a big scale, like the questions raised in Roy Greenslade's article do as well. Check out circusofthemind.net and please share this far and wide, because this is a bigger story than just the fact that my convictions are unsafe and many other Mahmood victims' convictions are unsafe due to the fabricated lies and the legal techniques used, and things completely just made up with no basis in reality. But also it's the fact that the police and CPS, massive disclosure failures, they turned a blind eye, they were fully aware it could not be trusted, and yet they let innocent people like me go to jail for no good reason. That's a malicious prosecution and they let it go ahead. Check out circusofthemind.net. Also, a Bellingcat article from November the 20th, 2014, the link for that, along with other links, will be above or below this video, brings up some interesting questions that have still not been answered. I quote from that article, "A week later, still silence from Metropolitan Police or CPS on Lord Goldsmith's call for a full review of historical Mahmood cases going back decades. Letters sent to DPP, Alison Saunders and Met Commissioner Bernard Hogan-Howe. In further developments, Bellingcat has been privy to letters that have been addressed to both Director of Public Prosecutions Alison Saunders and Metropolitan Police Commissioner Bernard Hogan-Howe as a result of Panorama's broadcast. The letters dated 17th November 2014 were sent from Siobhan Egan, who is a lawyer for one of the accused in the Beckham kidnap plot. In a letter to DPP Saunders, Egan demands a full inquiry into all historical Mahmood cases, and I'm happy to provide details upon request to the CPS." By the end of 2014, after the Theresa trial collapse, Siobhan Egan of Lewis Nadis Law took on my quest for justice on a pro bono basis and helped me with my first submission to the Court of Appeal and then the CCRC. Sadly, those failed for various reasons, as explained at circusthemind.net, but the fight continues. Anyway, other questions were also raised in that Bellingcat article. Questions raised by that Bellingcat article, link above or below this video, which will still not be answered. Number one, of the Met and CPS officers reviewing Mahmood's cases, as they were doing allegedly back in 2014, have any of them previously had anything whatsoever to do with bringing past Mahmood cases to court, whether it was a conviction, acquittal or collapse case? Number two, Bellingcat understands CPS casework is not that big a unit, and until government courts had a relatively low staff turnover. How many officers in that CPS unit that signed off Mahmood cases for prosecution? 3. Why did the Attorney General feel the need to intervene to discourage the BBC broadcasting Panorama when Mahmood had neither been arrested or charged with any criminal offence at the time? Therefore, contempt of court restrictions do not apply. And number 4. As the Attorney General has intervened, will he now consider his predecessor Lord Goldsmith's call for a review of all Mazher Mahmood past cases to be examined? That was 2014, late 2014. It is now June 2026. Yeah, 12 and a bit years on. And no proper investigation has been done into Mahmood's cases. The News UK News Group newspaper said they did an internal investigation, but they refused to give a copy of their findings to me during disclosure in Alex Smith versus News Group newspapers. That I would like the Criminal Cases Review Commission to use their powers to demand that News Group newspapers give them the results of their investigation, because the evidence shows, I assert, that they knew what Mahmood was up to. They must have done, because in 1994 the Police and Crown Prosecution Service communicated with each other in writing and stated that Mahmood could not and should not ever be relied upon as a witness of truth. And where were those documents? They were in the News Group newspaper's own archives. That's how I came to know of them, because they were disclosed during the mobile telephone voicemail interception litigation a number of years ago. The mind boggles. I want the CCRC to use their powers to get the Crown Prosecution Service to release all the details of how many other cases collapsed because of Mahmood's dishonesty and actions, and to find out why, when they had communicated with each other, the Met Police and CPS in 1994, why did they continue to turn a blind eye to Mahmood's dishonesty and continue charging people with malicious prosecutions and sending innocent people to jail, entrapped, manipulated, framed and lied about often, people to jail based on Mahmood's perjurous lies when they knew in 1994 that he could not and should not be trusted. Indeed, they acknowledged such in writing to each other. This is bigger than just about unsafe convictions. This is about serious disclosure failures by the police and CPS, and raises so many other questions that this really, really does need looking at. Please share this far and wide. Leveson Inquiry Part 2 was supposed to look at links between police, CPS and the media and criminality and cover-ups and corruption. And Lord Leveson said in a letter that Matt Hancock lied about in Parliament, making out that he made out in Parliament that Part 2 wasn't needed. But actually Sir Brian Leveson said it was needed, should go ahead, and should broaden its scope to also examine the activities of Mazher Mahmood. We need Leveson Inquiry Part 2 more than ever. The CPS need to disclose what they knew. The police need to disclose what they knew. And yeah, the truth needs to be out and justice needs to be done. Check out circusofthemind.net and also unsafeconvictions.com.